looking at hot employment law issues in 2025. First, by way of introduction in terms of your speakers for today. So you have myself, I'm James Pike. I'm a partner in the employment team in Manchester, and I'm really pleased to be joined by Jeanette Lucas, who is a partner in the employment team in London. So before we get started with our session, just a few housekeeping points to run through with you. So throughout the webinar, all participants will be in listen-only mode. However, if you wish to submit any questions, you may do so using the Q&A function and selecting the all panelists option from the drop-down list. We do have a lot to get through today, but we will do our best to answer some of the questions at the end of the presentation if we have time. And we will also be circulating a copy of the slides and a link to the recording after the webinar. Okay, so to start things off and just looking a little bit kind of very quickly at what's on the horizon. And the slide here just shows at a glance what is happening on the legislative front during 2025 and beyond. And obviously, we're going to be chatting through these developments in today's webinar and highlighting the key issues for employers to consider. Now, on a positive note, for this year at least, if maybe not beyond, it should be quieter on the legislative front than 2024 was. But obviously, employers shouldn't be lulled into a false sense of security, given the changes contained in the Employment Rights Bill that are on the horizon, and that employers really should be using this year to prepare themselves for the wide-ranging reforms that are going to be taking place during 2026 and beyond. Now, outside of those legislative changes, major theme that we are seeing for the start of this year and I think going forward is a real strategic shift in terms of just how much home working employers are willing to allow. More and more businesses now are seeking to encourage or even mandate that their staff work from the office for a greater percentage of their hours, or even a minimum number of days per week, while other employers have hit the headlines for pushing for a full return to the office. This is really something we've been getting more and more queries about how to handle and are supporting clients more and more with implementing those changes. And so it is something really to keep an eye out for. So that's the kind of bit on the horizon. I'm going to talk a bit more now about the Employment Rights Bill itself and providing an update on further potential changes. In terms of where we are with the bill, it's currently working its way through the parliamentary process and is actually receiving its second reading in the House of Lords today. And the debate ought to be taking place right now, in fact. So we're impeccably timed with this session. Now, obviously, the original bill was released last year, and as you may have read, there are a significant number of amendments that were tabled to the bill, both by the government and also some other interested parties, including backbench MPs. Having worked our way through those proposed amendments, I think it's probably fair to say we ought to focus on the government's proposals, as some of the alternative amendments were a little left field, and there's no pun intended given where those changes came from. But I think those aren't going to go and find their way onto the statute book. Now, some of those amendments are very much off the back of the consultation, and so to some extent it's positive that the government is listening to the feedback, albeit maybe query if they're listening to the right feedback if you look at some of the changes. But we do get a bit of an impression that some of this is being made up as they go along, and that's maybe slightly indicative of the issues that there were with the original bill, that it was a bit ideas focused perhaps rather than having the detail and thought as to what might be the practical implications for what was being proposed. Now, as for the consultation process, it's still ongoing. It's being undertaken kind of on a piecemeal basis, looking at issue by issue. And so there still will be a chance for employers to feed into some of those more impactful areas going forward. And I would encourage people to do so. It's important that the government hears from people and understands concerns they have, or maybe practical considerations that need to be taken into account. But I'd probably dampen any expectations that we're going to see material departures from some of those key changes that are being proposed, like day one unfair dismissal rights and the removal of fire and rehire. Those kind of key areas and topics seem to be really central to what the government has promised, and it seems unlikely they're going to be abandoned now. In terms of how that bill moves forward, we're expecting it to receive royal assent at some point in the summer, and then with all of the changes to be implemented in 2026, and the government's already said that the unfair dismissal changes wouldn't be to the autumn. So we know with those, at least we've got a little bit of time. The only exception to that is some of the trade union related changes which may come into effect later this year. So that's where we are on the bill. What we're going to talk about a little bit now really is going through some of those proposed changes to the original bill that was released last year. And the first one of those relates to collective redundancy consultation. Now, for those who are familiar with the original bill, what the government had proposed was removing the words "at one establishment" from section 188 of Tolruka, and the impact of that was to significantly widen the circumstances where employers had to collectively consult about redundancies, because it needed to look at redundancies across the entire business and not just in single establishments, whether that be a business unit or particular site. And it was a real cause for concern for employers who operate multiple sites, because it might significantly expand the circumstances where this duty was triggered, and there's lots of practical difficulties in running collective consultations from so many different and disparate establishments. So thankfully we have seen a slight step back from that proposal, albeit just how positive that change is remains to be seen. What the government's saying now will happen in the bill is that the duty to collectively consult will be triggered as it is now, where an employer proposes to dismiss as redundant within a 90-day period 20 or more employees at one establishment. But there's a second limb, but it will also be an and, where the number of proposed redundancies in totality hits a certain threshold. Now that threshold is yet to be determined, and so we're not clear just how and when it might bite. So really the duty to collectively consult is going to still be widened, just not as much as we previously thought was to be the case. But what we're really waiting for is that detail about the new threshold and when that duty will kick in, and whether they'll do it on a specified number, whether it be a percentage of employees in the workforce or some other calculation. But further information will hopefully come in due course. One of the other changes that we've seen in this area is the government is going to be increasing the maximum protective award that it can be made where an employer breaches their obligations to collectively consult. So currently that stands at 90 days pay, and that's going to be increased to 180 days pay. And I think that's consistent with some of the principles behind the changes in the bill, that the government's trying to discourage employers from almost kind of looking just to buy out particular rights and avoid these obligations. So that's what we're talking about, collective redundancy. We've also had further details about the government's proposed new Fair Work Agency and the powers it will have. As a recap, the Fair Work Agency is going to take over enforcement powers in a number of different areas, including things like national minimum wage and in relation to holiday pay. And now some of these changes are quite consistent with HMRC's existing enforcement rights within national minimum wage. So the Fair Work Agency, where it identifies a failure to pay employees correctly, will be able to issue a notice of underpayment, as is the case now with national minimum wage. And similarly, where that happens, the Fair Work Agency will also be able to issue a penalty of up to 200% of the underpayment that has been identified. That will be capped at £20,000 per employee, like national minimum wages. So it's bringing that current, and for those of you people who are familiar with national minimum wage audits, that current potential pain and risk that sits there when you have national minimum wage breaches, with breaches in other areas that are under the Fair Work Agency's powers. So things like holiday pay looks like it will be dealt with similarly. Other new powers that are being proposed relate to effectively supporting individuals bringing litigation, and there's two different ways this is going to happen, or is proposed to happen. One is a new power to effectively stand in the shoes of a worker and bring a claim on their behalf, That wouldn't apply for cases where the government can issue notice of underpayment, so things like holiday pay, minimum wage. And so it isn't immediately clear what the intention is with this power and when it might apply, but it's going to be there. Further guidance, obviously, is expected. The second area where they're going to kind of support people enforcing claims is the government going to have the power to provide or arrange the provision of legal assistance to a person who is a party to civil proceedings that relate to employment or trade union law or labour relations. I mean, it looks a little like the extension of legal aid to the employment tribunal system, something that's always been opposed on the basis it would be prohibitively expensive and administratively, unworkable. So it's one to watch for employers as to how that's actually going to work in practice, and how, given everything we've read recently, how it would be funded. But again, it's something to be aware of. And finally, for the things on this slide, there are also various changes that have been proposed around modernising the trade union framework, and it's not massively surprising that we have again further focus on trade union rights when you look at where the conception of this bill came from. Just picking out a couple of examples of what they're talking about. So the government's going to have the power to widen the means of voting, so that they can do electronic voting in industrial action ballots. Also looking at increasing the mandate for industrial action from 6 to 12 months, and also the notice period for how much notice a union has to give an employer for taking industrial action to be reduced from 14 days to 10 days. So moving on to some of the other things that are on the agenda. As people may have seen, the government will introduce a new rate of SSP for low earners. So employees who are unable to attend work due to sickness will either receive the existing flat rate of SSP or 80% of their normal weekly earnings. And the important thing being whichever is the lower. And it was a change I was getting quite annoyed about, because I was seeing lots of misreporting in certain areas of the press, being made to listen to Radio 1 with my children, and clinging on to my youth, that hearing them report it was going to be 80% of normal weekly earnings for all, it made me a little bit cross, because it's very much not the case, and would be much more significant change were that to be introduced. In other areas, we were waiting to see how much of the bill was to apply to agency workers, and in particular the very complicated changes proposed around 0 hours workers and what would be done in that area. And what we've had confirmed is that they are going to extend these rights to agency workers. So things like the right to guaranteed hours, reasonable notice in relation to shifts, and the right to payments for shifts where they are cancelled or moved or curtailed at short notice. They're all going to apply to agency workers as well. And now some of those proposals are kind of easier to accept than others in this area, but the idea of guaranteed hours for agency workers does seem to fly in the face of kind of the use of contingent labour, and it's really not clear how it's going to operate in practice. Further details are promised in separate regulations, and presumably that'll be when someone has worked out actually how this is all going to work in practice. Other kind of practical things that we've seen also introduced, so employers are having their record keeping duties extended to demonstrating that employees have taken statutory holiday and also paid holiday pay, and the duty will be to keep adequate records for 6 years, with offences being punishable with a fine. So it's consistent again with other kind of record keeping duties you've got around working times and minimum wage. Also, just as a reminder, the government is also going to be extending the time limits for bringing employment tribunal claims from 3 to 6 months. So if the whole raft of new rights that have been introduced wasn't going to increase the number of claims in the tribunal, I think the extension of time limits almost certainly will. Okay, moving on. So that's kind of a guide to some of the proposed changes to what we already knew in the bill. And as I said, whilst there's going to be some ongoing consultation and we might still see some tinkering around the edges of the bill, we really aren't expecting there to be substantial amendments. And so really change and significant changes coming and employers really ought to be taking advantage now of having kind of a 12-18 month lead in time to get themselves prepared for the bill. Now, just what preparation looks like for an employer is probably going to depend on their size and makeup of the workforce. But really, as a starting point, employers ought to be assessing the likely impact the bill will have on them, and thinking about things, for example, do you have a large number of 0 hours workers or agency staff? Do you take on a large number of new employees whose probation you need to manage differently now? Have you got things in your contracts you need to look at? So it's really now is the time to start undertaking that kind of impact assessment and getting prepared. And really, it should extend, I think, to looking at your recruitment practices and also your policies and procedures that affect the day-to-day management and termination of staff. Really challenging how robust are they? How much flexibility do they give the business? Are they fit for purpose in the new world? A lot of this focus is inevitably going to be around the introduction of the kind of day one unfair dismissal rights, and I think that's kind of correct, because it's going to result in more employment tribunal claims, undoubtedly. And so businesses need to ensure that policies and procedures are, effectively drafted in such a way as to maximise the chance of success if claims are brought in the tribunal. And also having those comprehensive policies is also helpful in deterring employees from bringing claims, because it's easier to show that you followed fair processes, but it also acts as a good support and guide for managers who are themselves having to navigate what are new processes in some instances. Thought is also going to need to be given to just how dismissals will operate through this new statutory probationary period. I think it's likely that you'll want a specific policy to deal with terminations during this time, but again, we'll probably wait for the further guidance around or the confirmation of the final version of the bill before those things are implemented. Other practical steps I'd be taking, reviewing existing contracts of employment. It's going to be too early to start making changes to contracts specifically to reflect proposals in the Employment Rights Bill itself. But it's prudent to start looking at them now and thinking about whether they provide you with the right amount of flexibility and protection that you need, particularly when you think about the difficulty that there will be in making changes to terms and conditions going forward. You might want to ensure that you've got necessary powers of variation or specific powers of variation where they're going to be required. And aligned to that, I would also be looking at whether or not you think there are changes that you need to be making to your existing terms. The window for effecting changes to contracts is pretty short now, and harmonising, and so changing terms and conditions going forward is going to be very difficult, given the inability to go through a fire and rehire process. So unless you can cross employees' palms with significant amounts of silver to agree to changes or can otherwise incentivize them, it's going to be difficult to make widespread changes. And so have a look at your contracts now. Is there a need to make changes? Is there a need to harmonize in areas of specific terms or policies or benefits? Are there things you need to be changing and doing them now before the Employment Rights Bill takes effect? Other things I'll be focusing on is the idea, greater training for managers, with that change to unfair dismissal, with a much greater focus on both recruitment and then dismissal during probationary period. Looking at the skill set of your managers, are there gaps there that you need to be thinking about plugging, and can we start that process now so we're getting people in good habits, we're encouraging them to or supporting them to make the right recruitment decisions in the first place, but then also where we identify that they haven't, we're dealing with dismissals appropriately and mitigating any risk coming out of those terminations. And finally, as I mentioned earlier, whilst I don't think we'll have substantial changes, we would still encourage everyone to engage with this ongoing consultation process, because even if the kind of key focus of the bill won't change, it might be that consultation makes some helpful little tweaks around the edges that employers appreciate. And then finally, on terms of some of the kind of the update on this part, there'd been a lot of talk about this new right to switch off, and the government had indicated it would bring in a right to switch off, which would be along the lines of changes that we've seen in Ireland and Belgium. I think where we're at with that now is that whilst there'd been talk that this wouldn't become a legislation, and instead we'd have a statutory code of practice, as is the case in Ireland. At the moment, there's nothing further in that, and in fact, press reports suggesting it's not going to be taken forward. So at the moment, it's not one to be concerned about. And we're also expecting further changes in terms of parental and carers leave, and one of those is around changes to the current or relatively new statutory parental bereavement leave to be replaced by a broader bereavement leave, which will give rights to not just parents but to others as well, albeit again, we haven't got the detail of who that would apply to. And then finally, for me, for the time being, we've also had further details provided around the proposals for mandatory ethnicity and disability pay gap reporting. So last week, the government was kind of issued a consultation seeking on views on how this was to be introduced. Now, the responses to that consultation, which will close on the 10th of June, is going to inform the government's approach to its new equality, race and disability bill, which is meant to be published later this year. So having looked at the consultation document, some of the key points to kind of highlight are, in terms of the reporting framework, I think we can be pleased to know that it's broadly going to be the same as we have for gender pay gap at the moment. So that's helpful in terms of we've already got systems set up and already familiar with what is required. And that means that for private sector employers, it's only going to apply to large employers in Great Britain, and that's the same definition as we have for gender pay, so those with 250 or more employees. And they're the ones that will be caught and be obliged to report on the same set of 6 pay gap measures that we have in gender pay gap reporting, and which are on the slide. Similarly, the date and deadlines are going to be the same as for gender pay gap reporting. So there'll be this snapshot date of 5th of April and a reporting date of the 4th of April. And all data is going to have to be reported online. And the proposal is that the Equality and Human Rights Commission will be responsible for enforcement. So the government is proposing to make it mandatory for infected employees to also report on the overall breakdown of their workforce by ethnicity and disability, and to provide the percentage of employees who did not disclose their personal data on their ethnicity and disability. The government's kind of rationale for that is they think it will give the context to an employee's ethnicity and disability pay gap figures, and will allow them to explain if their data has been affected by low self-declaration rates from their staff on these characteristics. We expect low self-reporting declaration to be a key issue for many employers and be one of the challenges in really providing anything meaningful when it comes to this area. I mean, not all employers currently collect this data at all, and those that do inevitably don't have complete data. So once these changes come in, there's going to have to be concerted efforts to obtain this information in order to allow some sort of reliable analysis to take place. One of the things we are going to see in terms of differences is that the government's proposing that employers ask employees to report their own ethnicity using the classifications in the government statistical service, an ethnicity harmonised standard as used in the 2021 census. And then what it's proposing is that employers will report their ethnicity pay gap data kind of using a binary comparison, and it sets out 3 possible options for this. So the first is the pay of white British employees compared with all other ethnic minority groups combined. The second is the pay of white employees compared with employees in the other groups combined. Or thirdly, the pay of the largest ethnic group in the organisation compared with all other groups combined. The government's preference is going to be the first option, but we'll obviously see where it lands on that. And employers are also going to be encouraged, albeit it's not going to be mandatory, it's currently suggested, to show pay gap measures for as many ethnic groups as they can. But there should be at least 10 employees in each ethnic group being reported on, sort of to protect the privacy of employees and to help produce more statistically robust data. Again, we'll have to see where we go on that. On disability pay gap reporting, the government is proposing to take a binary approach, and so effectively requires employers to compare the pay of disabled employees with just non-disabled employees, and to use the definition of Disability and Equality Act as the basis for identifying disabled employees. I mean, that's all well and good, but anyone who deals with kind of disability discrimination claims, will know that the bar for disability is quite low, but the number of employees who would probably appreciate they meet that is probably quite limited. And so you would query actually how many of those people will actually be captured through self-reporting and will actually understand that they would be considered to be disabled. We don't yet have an indication of when these provisions will be introduced, but I think it's fair for those employers who would be caught by this to kind of add preparation for mandatory ethnicity and disability pay gap reporting to their kind of ever-growing to-do list, as collecting and analysing this data is likely to be time-consuming, and there's a number of changes and new piece of information that they'll need to collate to do so. So I'll hand over to Jan for this next bit.
Thanks, James. So amidst all of that uncertainty, I'm delighted to be able to speak to you about something that is at least a little clearer, and that is the new statutory right for employees to take paid leave from work if their children are admitted to neonatal care, which is coming into force from the 6th of April, and it will apply to all babies born on or after that date. Now, just to put it into a little bit of context, this new right is being introduced in response to concerns that the current statutory leave and pay entitlements don't really support parents whose baby's born sick or prematurely and needs some sort of neonatal care in the way that they need. Although it's fair to say that those parents can, in that situation, use some of their other statutory leave and pay entitlements, campaigners for the new right made it clear that actually in practice that didn't work so well, and many parents were saying that they were being forced to either return to work whilst their babies were sick, to leave work, or to take unpaid leave or holiday to spend the time they needed with their child. Government estimates that around 60,000 parents a year would be eligible for this new type of leave, with around 34,000 parents likely to take it up every year. So it stands to have a substantial impact for many people who find themselves in this situation. In terms of the structure of both the entitlement to take leave and the entitlement to receive pay, well, mercifully, it is set up in a very similar way to other statutory types of leave. In terms of when the right accrues, well, it's going to be a day one right. So there'll be no qualifying period of service required in order to take the leave. And employees will be eligible to take neonatal care leave if their baby needs to be admitted into neonatal care within 28 days of their birth, and that care continues without interruption for at least 7 days. In certain circumstances, it may be that care in the family home also qualifies as neonatal care for the purposes of this new right to leave and to pay. So who then is eligible? Well, it will be available to those employees who would have had the main responsibility for caring for the baby had it not been admitted to neonatal care. So obviously that includes birth parents, intended parents in a surrogacy situation, the partner of the child's mother, and in some situations it will also include adoptive parents. It depends a little bit on when the child is placed with the adoptive parents and when they're admitted into neonatal care. And the leave must be taken specifically for the purposes of the care of the child. The new right to take neonatal care leave and pay is in addition to other statutory leave that parents are entitled to, so it doesn't encroach on entitlement to maternity leave, adoption leave, paternity leave, etc. And the amount of leave that they will be eligible for depends on how long the child is in receipt of neonatal care without interruption. but is capped at a maximum of 12 weeks. And I think that that is in part because, according to Bliss, who you'll probably know is the neonatal charity, the average length of a stay in neonatal care in England, Wales is currently around 7 days. Although obviously the most premature and the sickest babies can spend much, much longer in hospital. There are also provisions for dealing with the situation where more than one child is born as a result of the same pregnancy and receives neonatal care. So obviously we're talking about multiple births there, where the right to take leave will accrue in respect of both children, but again, subject to a maximum of 12 weeks. The leave must be taken before the end of 68 weeks, beginning with the date of the child's birth. And I think that is primarily to enable, obviously, the additional statutory leaves to be taken alongside that as well. And there's a slight difference with the neonatal care leave in the sense of when it can be taken. And there are two distinct periods. The first called the Tier 1 period, which is leave that can be taken while a child is in neonatal care and the week after they are discharged, as compared to the Tier 2 period, and that is leave that can be taken at any other time during the 68-week window that I've just mentioned. In relation to the Tier 1 period, the leave can't start before the second week of neonatal care. And after that, it can be taken in consecutive or non-consecutive blocks of a week. And any leave the employee chooses not to take in that Tier 1 period can then effectively be carried over into the Tier 2 period. But if they do that, it must then be taken in one continuous block. And obviously that's subject to the maximum of 12 weeks, but it still is linked directly to the amount of time that the child is actually in receipt of neonatal care. As with other types of family-related statutory leave, there are certain information and notice requirements. So in relation to the Tier 1 period, for example, the employee needs to notify their employer before they're due to start work on the first day of absence or as soon as reasonably practicable thereafter. But that notice does not have to be in writing. And I think clearly that is recognition of the fact that these situations very often arise urgently. And it's obviously a very stressful and distressing time for the parents. For leave taken during the Tier 2 period, there is a longer notice period that applies there. So the employee has to provide at least 15 days before the start of a period of 1 week's leave. For 2 or more weeks, the employee has to provide notice of at least 28 days before the start of the leave. And in both cases, the notice has to be given in writing. There is a distinction here, though, because unlike other types of statutory leave, the leave regulations specifically say that the parties can mutually agree to waive the requirements to give notice. And if they do that, then the employee is treated as having complied with the statutory notice requirements. And again, I think that is designed to enable some flexibility in what is obviously a very difficult time for the employee. Just turning briefly then to the rest sort of the structure of the leave arrangements in terms of the terms and conditions that apply during neonatal care leave. Well, these are the same as with other types of family-related statutory leave. So all terms and conditions of employment continue to apply in the usual way, as if the employee had not been absent on leave, except those relating to remuneration, so wages or salary. So that obviously includes things like holiday accrual, pension rights, qualification for bonuses, that sort of thing. Similarly, in relation to return to work, if an employee who takes neonatal leave care returns to work within 26 weeks, then they have the right to return to the same job. And that 26 weeks will include not just neonatal care, but any other statutory leave that they take during that period. If they return after a longer period, i.e. 26 weeks or more, then they return to the job they were employed in before their absence, or if not reasonably practicable, to another job which is suitable and appropriate for them in the circumstances. In terms of eligibility for pay, again, the employee must have at least 26 weeks continuous employment ending with the relevant week and be earning above the minimum earnings threshold, which from April 2025 will be £125 a week. The maximum period for which neonatal care pay can be paid is 12 weeks, so that obviously links to the maximum period of leave. And the government has indicated it will be issuing some additional guidance, as has ACAS. The government initially said that it would publish that guidance fairly soon, but having checked this morning, we haven't seen anything from the government or ACAS on that yet. So watch this space. In terms of what that means for you as employers, well, I think there's a couple of things. There's a question as to whether or not you update your existing leave policies to reflect the neonatal care leave and pay entitlement. I think the most important thing, though, is to make sure that your managers are aware of the new statutory leave entitlements and how they should deal with any requests or employees who find themselves in that unfortunate situation, to ensure that they are able to deal with those requests quickly, compassionately, and with minimum fuss, I think, for the employees. There may also be a question mark as to whether or not you want to enhance the statutory provision, and I think that is something that you need to consider in the context of your overall approach to statutory leave and the extent to which you enhance the existing benefits in place. As I say, look out for the ACAS guidance, the government guidance, which we anticipate coming soon, but otherwise focus on your internal policies and what you might do there, and ensuring your managers are equipped for the conversations that they might now be asked to get involved with. Okay, so moving on then to the next topic I just wanted to touch on very briefly, which is the new failure to prevent fraud offence. You may or may not have heard of the Economic Crime and Corporate Transparency Act, which was issued in 2023, which created a new corporate offence of failure to take reasonable steps to prevent fraud. And what that essentially means is that affected employers can be liable where a particular fraud offence has been committed by their employees or other associated persons for the employer's benefit, and they did not have reasonable fraud protection procedures in place. Now, I think this obviously isn't a pure employment matter as such, but if you bear in mind that associated persons for the purposes of this new offence will include your employees, agents, subsidiaries, and other individuals and entities who are providing services on your behalf, you can see why it may be something that crosses your desk, particularly because the way that the offence is structured, and in particular the way in which employers might be able to defend any prosecution brought of them alleging a breach of the failure to take steps to prevent fraud. It's going to be set up in a very similar way as the framework and approach that we saw to anti-bribery legislation. And what that means is that there are going to be what are called the 6 fundamental principles. Those six principles include top-level commitment, so ensuring that your senior management team, your board, are fully committed to ensuring that appropriate steps are taken. It's going to be a risk-based exercise, so you'll be looking at risk assessments, considering where these frauds might occur, implementing risk-based prevention measures, carrying out proper due diligence, and from your perspective, it will also involve training and communication of the risks of the fraud and the processes that must be followed to avoid those potential frauds taking place. And when we're talking about fraud for the purposes of this new offence, we're talking about things like dishonest sales practices, accounting practices, false statements to investors. There's been quite a lot of discussion as well around greenwashing and blue washing in an ESG context, and also falsification of clinical trials. But they are only examples. The scope of this new offence is very, very broad indeed. And so it's of real importance, particularly because in the event of a successful prosecution, it could lead to unlimited fines being imposed. Now, it doesn't apply to all organisations. In order to be susceptible to the new offence, it requires you to meet 2 out of 3 criteria, and they are more than 250 employees, more than 36 million annual turnover, and or more than 18 million in total assets. But it's important also to note that you might be caught as an individual company or entity, but those thresholds can also apply at a group level. Now, if they only apply at a group level, then where the liability for this new offence sits might be slightly different, because it might sit with your parent company rather than the employing entity that you sit in. But in order to determine where that liability applies, if it applies at all, is not an entirely straightforward exercise. So it's well worth you spending some time to identify whether or not you are caught. As I say, I mention it because from an employment perspective, there are certain policies, procedures, training, etc., that you will need to put in place if you are caught, in order to be able to support your defence of any attempted prosecution. And I think it's also worth bearing in mind that, you know, this is one of, I think, an increasing number of offences and approaches where the employer is really expected to take a much more proactive approach to prevention rather than dealing with it if it arises. And of course, we have seen something very much in the employment context along a similar vein in relation to sexual harassment. And I think that's a reflection of the difficulties, particularly with fraud, that the responsible authorities have had in bringing these prosecutions and actually trying to shift that burden onto employers. And as I say, we've seen something similar in relation to sexual harassment as well. Okay, moving on then to artificial intelligence. Now, this is really something that we are very much seeing as a hot topic, just generally, but also very much in an employment context as well. There isn't really any legislation, at least in the UK, that deals specifically with AI. But of course, the use of AI in employment context does fall within the scope of existing laws, and you know, in particular, the use of AI tools in recruitment is something that has come under quite a lot of scrutiny. There is a white paper, as has been mentioned there, and that white paper makes clear that there are no plans at the moment to make material changes to existing legislation, which already touches on the use of AI. That would include things like the GDPR, for example, our non-discrimination legislation, all of which the government expects to continue to operate in parallel with any sort of industry-specific AI rules. And actually, there have been, not rules exactly, but we have certainly seen some industry guidelines being issued around the use of AI, particularly, and I've just mentioned recruitment, but there is a set of guidelines called Responsible AI in Recruitment, and the ICO, the Information Commissioner's Office, has also issued some guidance and toolkits around the use of AI. So there is some potentially helpful collateral out there. The AI white paper, as I say, outlines 5 key principles, which suggests the sort of direction of travel that is going to be taken as far as the approach to AI regulation in the UK. Those principles are safety, security, and robustness, and that really is what it says, the requirement to ensure that AI systems operate in a safe, secure and robust manner. Appropriate transparency and explainability. And I think that this one is absolutely key in an employment context. If you think about the fact that, ultimately, when we're talking about AI, you're talking about training a machine to take certain decisions. And the reality of it is that given that those machines are trained by humans, then it is perfectly possible for those machines to learn our own conscious and subconscious biases. And that does mean that, the inadvertent use of a discriminatory selection criteria in either a recruitment context or possibly a redundancy selection process will mean that that same criteria keeps being applied in similar situations. And because AI machines learn from past outcomes, the repetition of that type of decision making can also then amplify the effects of that discrimination. And the other difficulty with reliance on AI in those sorts of situations, of course, is that the machine is not able to sort of mitigate the impact of bias because it doesn't recognize it. And so that really brings us back to the idea that whilst these tools might help facilitate these processes, there is still very much a need for human intervention and human oversight, because where you rely on those decisions, that machine-led decision taking in any of your employment processes, the reality is that you as employer are ultimately still responsible for any decisions taken based on those machine-led outcomes. And that can lead to, discrimination claims potentially, because of biased recruitment decisions, unequal treatment, and that can be actual unequal treatment or the perception of unequal treatment, which in many cases is actually the more difficult of the two to manage, and unfair dismissal cases as well. The expectation is very clearly that were you to rely on one of these decisions, you would have to be able to explain how that decision was taken. And what I mean by that is that you have to understand how the AI tool that you have used has actually reached the conclusion that it has. And if you're not able to do that in a clear and transparent way, then there is every chance that a tribunal would reach the view that you hadn't shown that you had taken reasonable steps and that it was a fair process, and you then as employer become at risk of an adverse decision because of a flaw in your AI processes. In addition to that transparency and explainability, and linked to that really is the principle of fairness. So quite clearly and squarely in the context of what we've just been talking about, the white paper makes clear that the use of AI systems should not undermine legal rights and should not unfairly discriminate. So that relates exactly to what I've just been talking about. And accountability and governance, again, that is linked because any user of AI, particularly in employment context, must make sure that they have appropriate governance measures in place to make sure that the AI systems are controlled, they're understood, they're managed in an appropriate way, and that if their use is producing outcomes that you are not comfortable with, that you take appropriate steps to address that. The other context in which we have seen quite a few questions coming up in relation to AI is not its use by the employer, but actually the use by employees. And we've also seen quite a lot of conversation around this concept of shadow AI use. Now, AI obviously is potentially a useful tool to your employees, but as with any other tool, it's really important that you are clear with your staff about the ways in which it may and may not be used. And again, this goes in part to protecting yourself as a business, but also in part to ensuring that if you have clear processes in place, then employees understand what they can and can't do, and your ability to discipline and potentially dismiss in the event that they breach those procedures is much clearer. This concept of shadow AI use it's creeping in, where employers have introduced policies which make clear that employees must not use their systems and their devices to access or use AI tools. And so instead, they use their own devices to access those tools and then import it effectively onto your systems. And so, again, that is something that you would need to address in any policy regarding the use of AI, should you decide to introduce it. I think watch this space as far as regulation is concerned. Mentioned on the slide there is the EU AI Act, which has been around since 2024, but the rules under the Act are being phased in over a period of time. We've already got in place prohibited practices, but in August 2026, there will be a new set of rules coming into force in relation to high-risk systems. And those high-risk systems include biometric identification and categorization of individuals, its use in education and vocational training, and its use in employment, worker management, and access to self-employment. Now, whilst the Act as an EU Act may not necessarily apply to you as a UK employer, it does have extraterritorial scope. And so if you have operations in Europe, if you deal with individuals who are based in Europe, you could still be caught. And going back to what we were saying in relation to its use in the context of employment, recruitment, etc., its high-risk systems will again be subject to tighter control and regulation. So I think that's it from an AI point of view. So if I can just hand back to James to talk about the national living wage and the national minimum wage, just to finish this off.
Thanks, Jeanette. Yeah, so really we are just to highlight changes here, and the kind of continued significant increase of all of the minimum wage rates. So the top rate of minimum wage, obviously called the national living wage, is up from £11.44 to £12.21. The rate at 18 to 20 is up from £8.60 to £10, and the 16 to 17-year-old and apprentice rate is up from £6.40 to £7.55. So you can see that they are fairly significant rises once again. This is an area that we're continuing to see employers being caught out by inadvertent breaches of the minimum wage. And I think that's only likely to continue to be the case as the rates increase and more employers are effectively brought within its scope, because the cushion that they might currently enjoy or have historically enjoyed over the minimum wage is eroded, and in some respects to nothing, and employers who were never previously minimum wage employers now are. And that means that they can be caught out by a number of the kind of areas, the kind of inadvertent breach that we see, because the rules in this area are quite complex when it comes to how you calculate the minimum wage, and particularly things that you need to take into consideration. So areas like employees having to pay for employment related costs, like elements of uniform, salary sacrifice arrangements, continue to be an area we see cause issue, and also things like employees working through unpaid breaks or having to attend unpaid pre or post work meetings are all things that continue to create risk and are issues we still see arising. So really it's a kind of a cautionary tale and a point to flag that if you are in a business that is kind of getting and finding itself creeping closer to the minimum wage, and you're not perhaps as familiar with some of the rules in this area, it might be something you want to look into and start assessing the risk, if any, that exists. And in other areas where we've seen increases, and this is just to flag them, if we can just, yeah, thank you, move the slide along. So also there's just to make you aware of the increases in the in certain rates and tribunal awards. So as is the case every year, the compensatory award for cap for ordinary unfair dismissal claims is being increased. It was £115,115, which was really helpful for us to remember. We're now going to the less handy £118,223. The reminder is, of course, that is the overall cap that can apply to any ordinary unfair dismissal case, but the cap will be the lower of that figure and 52 weeks pay for the individual. So more often than not, we don't have to concern ourselves with that sum. Also increasing is the cap on a week's pay for the purposes of statutory redundancy pay and the basic award. That's going up from £700 to £719. And those changes are going to take effect for dismissals on or after the 6th of April. So anything which has already happened, cases that are already in tribunal, they'll be under the old rules. It's only dismissals after the 6th of April it relates to. Other areas of increase, just to flag, SSP is going up to £118.75, and the rates of SMP and other family-related leave is up to £187.18.
Okay, so just to finish us off then, although the UK is obviously no longer part of the EU, there are a number of changes coming down the line which will be relevant to those businesses who have a presence in the EU or do business with EU-based businesses. And one of those to mention, and this is something we're talking to a lot of our clients about at the moment, is the Pay Transparency Directive. You may well have heard of this already, but it is Europe's attempt to really try and force change to support the closure in the gender pay gap, because despite many years of pay reporting, and most, if not all, member states currently do some form of gender pay reporting under their national legislation, the gender pay gap across Europe remains stubbornly high. It's an average of around 12%. And so the thrust behind the Pay Transparency Directive is, as it says on the tin, if you like, and that is really a set of transparency provisions which are intended to force employers to be much more open with their employees about the way in which pay is set and managed within their organisation, as well as greater access for employees to information about not only what they are paid, but how their pay compares to others at doing a similar job, or for the first time, this concept of doing work of equal value. I mentioned that there's a set of transparency provisions, and they apply regardless of the headcount that you have in each of your European locations. In addition, there are pay reporting obligations that will sit alongside and in addition to your existing domestic obligations in that respect, and they will apply on a almost a graded basis, if you like, depending on your headcount, subject to a minimum of 150 employees or more. There, as I say, the implementation date for the directive is June 2026, which might sound like a long way away, but in order to be properly ready to meet the various requirements of the directive, there is quite a lot that needs to be done. And so if you think you may be caught and you haven't yet started preparing for the directive, accepting that with the exception of Sweden, none of the member states have so far announced any draft legislation to implement the directive, then we strongly recommend that you start thinking about your preparing for that. And of course, if you need assistance with that, then we're more than happy to talk to you. That, I think, brings us to a close for today. I'm conscious of time, and so I think we will finish there. But thank you all for participating today. If you do have any questions about anything that you've heard, please either drop them into the chat or contact your usual Squires contact. And as mentioned at the beginning of the session, we will, as we always do, be circulating the webinar slides and a recording link after this session finishes. So please keep an eye out for those. Thank you again, and have a good rest of the day. Bye.